Just in your own words, yeah. Just to start sharing. What's Justice Harlan saying as his dissent?
They're making laws, so they probably have the broader reasons, like going back to indirect versus direct. Like they make the laws, they may not be.
What precedent does Harlan really rely upon in his dissent? He's very intense here on this one. Yeah, McCulloch v. Maryland. What does he say about McCulloch?
Just says in the powers of all, just representing all, acting for all, public hearing.
All right, so let's take a step back. Okay, so who is Justice Harlan? You know what his full name was? John Marshall Harlan. Who was he named after? The Chief Justice. When you're named after a justice, you're set. He's one of my favorite justices of all time. He's definitely in the top 5. We'll study later this semester sort of Harlan and who he was, but he was often the lone dissenter. He was the lone dissenter in Plessy against Ferguson, the case establishing separate but equal principle. He was the lone dissenter in civil rights cases, which stopped the famous Civil Rights Act of 1875. He was all by himself in a lot of cases. And he was, I'm not going to exaggerate, he was a bit of a visionary. He was able to sort of see where the law was headed decades ahead of his time. It's really remarkable. I had the good fortune to do a paper on him. I was in law school. He was a law professor, just like me, right? He was a Supreme Court justice. He was an actual Supreme Court justice teaching con law on the weekends or in the evenings, the evening students. He would go work on the day and go teach. It's what's now George Washington University. It wasn't called that then. It was called Columbian Law School. And one of his students in the 1890s transcribed his lecture notes. They didn't have Otter, right? He actually wrote shorthand all his lecture notes, and I typed them up as part of a paper. And he would say things that were just so insightful. And I actually used some of Harlan's stuff in my class. I won't even tell you. I'll tell you. The stuff about the supremacy clause, he would always say, the supremacy clause is the most important part of the Constitution. And I say the same thing. Like, I'm giving you Harlan's lecture notes, like cribbing it. It's just awesome. But and here comes the big but, he was in dissent here. But this was a 5-4 case. And I think Justice Harlan recognized that this decision would not work. And I want to now address what Conrad and what Oscar were asking at a minute ago. If you notice, the majority doesn't talk about the means, the ends very much, right? Let the ends be legitimate. Let the, they don't use that sort of language. And Harlan saying is, whoa, what happened to McCulloch v. Maryland, right? This is a case that we've been reading for more than 100 years by this point, or, nearly 100 years. Why are we not talking at the means, the ends? So what does Justice Harlan say? Right? What does Justice Harlan say? He says that the Constitution gives Congress a lot of power to do what? To protect commerce from burdens. What are these burdens? A monopoly. What is a monopoly, right? A monopoly is when one company has too much market power. And it burdens the transportation of sugar from one state to another. And he says this, just look very, so I want to just read this one sentence. He says, monopoly affects, not incidentally, but directly, the people of all the states. Again, monopoly affects, not incidentally, that is not indirectly, but directly the people of all the states. Elizabeth, why is that sentence so significant I just read to you? I'm sorry? You're correct. Let me just drill you in a little bit more. What's the meaning of this phrase affects, right? Affects the people. Well, Why is that significant? Why is it affecting the people? People? But it says this affects people. He doesn't say this regulates commerce. It says it affects people. Oh, but he says it's not indirect. You're correct. You're good. Fidel, you want to add something? So it's one step removed from the commerce. It's not just the commerce. It's how the commerce affects the people. So is that regulation of commerce or something else? Elizabeth? Perfect. Broader. So you see what Harlan's doing here. It's like, look, he's saying, no, this is not indirect. This is direct. But direct of what? It directly affects the people. And what does that mean when you affect the people? It's not regulation of commerce itself. It's regulation of something broader. All right? I'll give you a little hint. Whenever you see the word affect, A-F-F-E-C-T, affect, that's a trigger, that's a tell that we're talking about necessary and proper and implied powers. So when Harlan says it's not incidental, that's not exactly right. It is implied, right? Okay. And then Harlan says, I want to just read one more sentence to you. Again, Harlan was a very clear writer. A lot of decisions from this period are not very clear. He wrote well, and his decisions have aged well over 100 years later. So he says, Congress can reach whatever, right? Whatever. Congress can reach whatever improperly obstructs the free course of intercourse. Congress can reach whatever improperly obstructs the free course of intercourse. So it's not just regulating the trade itself. It's about removing any sort of barriers or things that might block that intercourse. Everyone with me? All right. And then Harlan goes on, he quotes from McCulloch, Maryland. Let the end be legitimate, let be within the scope of the Constitution, and all means which are appropriate, which are plainly adapted to that end, which are not prohibited, and so on. Right? So he's saying this is the rule from John Marshall not Joshua Harlan, Chief Justice Marshall from 75 years ago. It's been repeatedly reaffirmed. All right, so now I want to come back to the question that Conrad and Oscar asked me a few minutes ago. I'll go to Shelton for this one. Harlan talks a lot about the means and the ends, right? So Shelton, let me ask you a question. What is the end? What is the goal that Congress is trying to accomplish here? What's their end? What are they trying to achieve?
To eliminate the control of manufacturers by local.
Correct. Right. It's to eliminate too much market power, too much market share from one company, and that could create these unlawful, burdens of commerce. Is that legitimate, Shelton? Is that end legitimate? According to, I'm gonna ask what you think. According to Justice Harlan, is that a legitimate end?
Yes, according to Harlan, it is legitimate.
Do you think the majority thinks it's legitimate?
I do think the majority would think that it's legitimate.
Well, which branch of government do you think the majority thinks should be concerned about these barriers to trade between the states?
I think the majority would say that it is the state's obligation to control it because.
Yeah, I'm not sure. I think you might be right. Maybe yes, maybe no. I'm not positive. The majority doesn't really say. But let me ask you a follow-up question, Sheldon. How can a judge sitting in his chambers with his law clerk? Actually, they didn't have law clerks back then. They actually did the work themselves. It's much better. So you don't have these long opinions that are impossible to read. Sheldon, let me ask you a question. How is a judge to decide if an end is legitimate? Who's a judge to decide this question?
Are you asking for my opinion?
I asked you a question. You can answer it.
I don't think the judge is appropriate to decide.
So who, if not the judge to decide it's appropriate, who is to decide it's appropriate?
I believe it's not stated in the Constitution should be left to the states, and the
Mm.
judge should not decide whether or not.
Well, is it left to the states or left to Congress? Isn't that the question? Whether the states or Congress is doing it? How do we know who this is unless the judge gets to decide it?
Well, I believe, he squeezes it into the necessary and proper, but
Uh,
I think it's a squeeze, so I think it should have been left to the states, or the Congress can enact some kind of law, or
Yeah.
make some kind of constitutional change.
Marilyn, did I call you last time? I can't remember if I jumped over your wing. Okay, I'll call you now. Okay. And Zoe, if who's not here, she'll get it eventually. How can a judge decide if something's legitimate? Or maybe use a different synonym, reasonable, right? Judges decide reasonableness all the time, don't they? Use the torts, I guess. How is a judge to know what reasonableness means? What appropriate means? What legitimate means? This is not. How's a judge to know?
I think they have to look and see, they have to make sure it's not prohibited.
Oh yeah, though that's the easy part, right? There's nothing banning this, but the question is this a legitimate end? Let the ends be legitimate. Martial rights is in plain letters, right? How's the judge to know if something's legitimate?
It also has to be reasonably related to the goal.
I want to get to that in a minute. You're right, but let the end be legitimate, right? How do you know if an end's legitimate? I want to just focus on that for a minute. Yeah, but how do you know that? You're giving me good stuff, but it's so circular.
Sorry.
No, don't apologize.
That either there are enumerated or implied powers in the.
Oh man, no. Conrad, okay, you're next, I express, my friend. How is a judge know if something's legitimate? This is sort of your question a few minutes ago.
Feels right?
It feels right. You got the vibes, right? You got the feels. Is that what we're down to? Is it feel good? James Brown? I mean, what?
That's the same thing with reasonableness. Is it just if it seems correct?
How does your tort professor define? I did not do well on torts. How do you define reasonableness? Isn't there just? Yeah, but who's this? Who's this reasonably prudent? Have you met this person? Is he? Can I say hi to him? Hey, what do you think? Where is he? Is he in this room? Bobby, how is a judge to know if something's legitimate? If it's appropriate? Is there anything to go on?
I mean, they just look at the goal of what they're trying to accomplish, like what Congress is trying.
Okay, they look at it. They say we eliminate these restraints, and how do you know if that's legitimate?
Well, it seems to vary with the times. I mean, you got Reconstruction, then you've got Progressive, so they kind of view it in light of that, I guess.
Oof. All right, anyone else? Even Michael, been waiting patiently with the hand up for a while, and I kept bouncing over you.
Well, now I don't think it's right, but I thought they would look to the enumerated powers.
Oh, that's what she was saying a minute ago, but yeah, that doesn't get you very far, does it? So look, Stephen, you want to add something, Angelica?
Look at the case law, like what's happened in the past to decide.
That's an answer, but how did those judges know? I mean, it's sort of a chicken and egg question. How do you know those case judges were right? Yeah, Angelica?
I was just going off what you said last time, how close it fit to something.
I want to get to the fit in a minute, right? But I'm just saying, look, I'm going to read Marshall again. Let the end be legitimate. That's it. How do you know if an end is legitimate? I'm just that one sentence, Trent.
I think it just comes down to, I mean, kind of like the people who wrote like the original Constitution. It's all about like use your own informed like opinions.
The judge's opinion. So this is not external. This is internal. What you're saying to the judge. William, and then Chelsea.
Yeah, I think there is no fine line, and that's why the case is flip-flop.
Oh boy. Okay, now we're getting somewhere. We're cooking with gas. Chelsea.
So if you look at the clause, like the commerce clause, they look and say like it grants the Congress the power to regulate commerce with foreign nations. So they go to that, and if that's the end, then it's like, okay, well, this is reasonable.
Well, this is not a regulation of commerce, though. It's saying it's trade. It's Shrey's point a minute ago. It goes beyond it. In other words, you want to. A couple of you said you look to the enumerated powers as listed. That doesn't get you very far. That doesn't get you to whether an end is legitimate. So I'm going to stop you, and I appreciate this discussion. There's not a good answer, but let me try to synthesize it. There will be a lot of times this year where the court asks, is the end legitimate, right? Does the state have a legitimate interest, right? Does the state have a compelling interest? Does the state have an important interest, right? Sound familiar? There are all these tests in constitutional law, but asking whether the state has a valid interest. Who is a judge to decide? So a judge might say, look, I'm just a judge, right? I'm not a legislature. If the government says this interest is legitimate, by golly, that's good enough for me. Or a judge might say, you know what? I know better. I know better. I am informed. I am wise. I took an undergrad class in philosophy, right? You know, I'm exaggerating slightly, right? I know better. I know it's legitimate. And the government says this is legitimate? No, I think it's wrong. This is for the states, not for the federal government. Maybe I have a very strong view of federalism. I think that this is not a legitimate power of the federal government. Maybe I have a very broad view of federal power. This is where judicial philosophy kicks in. And I don't mean Republican versus Democrat. It's not that. Judges, all of us, everyone in this room, I promise you have a philosophy. You don't know what it is yet. Maybe you do. But you all will have a philosophy, and I'm not going to teach what that is. This comes from who you are, your experiences, where you've been, what you've studied, what you've seen, how you think about things, who your friends are. We all have a different way of approaching the questions, right? There's no one way. I have friends, and we often think about things the exact same way and come to opposite conclusions. It's not because I'm an idiot and he's stupid, or we just have differently wired brains. And in this class, more than any other, you see that come out. The 5-4 majority opinion in E.C. Knight and the reversal a couple of decades later in Hammer reflect these different views of federal power. If you sort of start from the presumption that it's not legitimate for Congress to regulate monopolies for the states, well then, yeah, this is not a legitimate end. If you start from the presumption that, yes, we need a central government who can eradicate these barriers between the states and have free trade, then yeah, this looks like a legitimate. Let the end be legitimate. That's the first thing. How do you know if the end is legitimate? There's no bright line. There's no text you can point to, right? It comes from within. And you can see Justice Harlan for the dissent and the majority opinion by Chief Justice Melville Fuller, who had an awesome mustache, by the way. Have you ever seen Fuller? This guy, I mean, just he looked the part of being Supreme Court Justice. Let's see, yeah. Look at this guy. He thinks commerce succeeds, manufacturers not a part of it. That's what he believes. Okay.
So it just depends on what justice is making the decision.
Oh, now we're getting somewhere. So there's a reason why Supreme Court politics are so important. And it's not just today in 2025. They were always important. I mean, look at the legal tender cases, right? The Supreme Court declares the Paper Money Act unconstitutional, and then President Grant says, okay, that's fine. I'm going to have 2 new people on the court who favor paper money. And what happens 1 year later? They reverse it. So since the beginning, there have been fights over judges and their philosophies. I mean, why do we have Marbury against Madison, right? The first case of the semester. Because Jefferson said, screw this. I'm not appointing any of the Adams guys. I want my own people in the courts. From the very beginning, from 1800, this has been an issue. Now, I believe this firmly that judges do try their level best to decide cases fairly, not according to their prejudices. I believe that 100%. But we all have different philosophies, and that yields difference in outcomes, right? And sometimes philosophies don't always coincide. I mean, the current court, a lot of the justices have been unpredictable. Justice Scalia and now Justice Gorsuch have a very strong sense of criminal rights. They favor the accused. It doesn't always line up the way you might think. Justice Jackson, she was a federal defender, and she's ruled for the prosecutor quite a bit. Things don't always line up as you might expect. In fact, I was at a conference this weekend, and all these defenders like, what the hell? Jackson's ruling against the defendant all the time. They're kind of surprised by this. They're kind of like annoying people. So judges don't do as you might expect them to do always. They have their different proclivities, but they have their own philosophy. That's how they decide their cases, right? I mean, if any of you, your judge thing, they went to Phoenix, right? If you ever ask a judge how do you decide a case, that's a good question to ask them, because they're going to struggle. They'll say, oh, we follow precedent. Okay, that's nice. Okay. And oh, we follow the statute. Okay, that's nice. But there gets to a point where the precedent doesn't tell you the answer. The statute can be read 1 of 2 different ways. Lawyers on both sides giving you pretty good arguments. And what are you going to do? There's judgment, right? Hamilton says Federal 78, neither forced nor will, just judgment. And that's what judges have. And that's what you're all trying to sort of internalize and learn about.
I have a question.
Yes, ma'am.
I had a judge I asked, and he said that the law should be predictable and dependable.
That's a good rule.
So, I mean, in our cases here, like in the eras, some are not. But is it like, just in your opinion, or just from this class, is it like it should be, but it won't always be? Like
There.
the law should be predictable and dependable, but it won't always be.
Can I ask, was the trial judge or an appellate judge?
I believe he was a justice. I don't know his name. It was a guy, Terry, somebody. I think he was a justice in the first.
McAdams?
Yes.
The Chief Justice?
Yes.
Yeah, I know. Very good judge. He's in love with this law school, by the way.
Yes, he
Yeah.
did our oral argument.
Oh, he's a very good judge. I think predictability is good. I think certainty is good. I think that's also good. But sometimes people want to change the direction of the law. I think that the law has been the way a certain time. Maybe it should not be going that way anymore. So these are just different competing values. If you take the position that law must be predictable, then it's never going to change. Right? I mean, you can't do both, right? You can't make it predictable and change it, right? Because predictable means you're not changing it. Also, he's an intermediary court judge, and it's a different standard than a state Supreme Court judge or U.S. Supreme Court judge.
Yeah, he said that, like, he's like stuck to.
As they say, middle management, as they say. Good question. Oh, yes. Is that Sabina?
Yes.
Good.
What I think from this case is that what Harlan is really getting at, that one state cannot fully regulate, cannot fully control, and so it's going to be more injurious to.
I'm going to do that next. You're like 5 seconds ahead of me. You're correct. Okay.
So would that go into like the predictability type of thing?
This now goes into the means, the ends relationship. When people keep asking, I tell them to come back to it. But yes, what Harlan understood, and he put this in his lecture notes that I studied, is that when you have a national economy, it's simply not possible for any one state to eradicate monopoly. It's impossible. You need a national solution, right? One state can only police what's within their own borders. So Harlan first discusses, are the means legitimate? He's like, yeah, of course they are. Right? I'm sorry, are the ends legitimate? Yes, they are. Who can say that the end is not legitimate? Right? Who am I to say? He defers to Congress in this. Then he gets to the means. Here's what he says. The means employed are suppression of monopoly. Right? You're shutting that monopoly. Those are the means. Then he says, are the means appropriate to accomplish the ends? In other words, if the end game, the goal is to free the channels of commerce and the means is to eradicate monopoly, is there a relationship between cleaning the channels of commerce and getting rid of monopoly? He says there is. Who can say that such means are not appropriate? These means will attain the end of freeing intercourse among their states from burdens. Congress can remove the burdens by banning monopoly. And if they do that, the channels of commerce will be wide open, in theory at least. Everyone see that. He sees a close fit between the means and the ends. If the goal is freeing the economy from these monopolistic prices, banning monopolies is a appropriate way of getting there. The fit between the means and the ends is tight. Conrad and Oscar, now did I finally answer your question? No? Kind of? I'll go with kind of.
I'm kind of thinking more like who was in your pockets in the first place, you know?
No, don't say that. I don't think that at all. No, there's not even. This is, again, I know you like to be cynical and think this is bribery. I don't think that at all. This judges have different perspectives of the role of the state and the federal government. If you're in the majority, this is like an act of basically seizing the power from the states that they have. Because once the power is taken from the states, the federal government, it ain't coming back. Right? So they're more concerned about that than the cost of sugar. Okay. And finally, this was Sabina's point a moment ago, it's only that Congress can regulate this national market and not the states. Okay? Everybody with me? Very important case, East United. It's actually a very teaching case. The facts are so simple. It's like sugar, right? This is not, we'll have some pretty complicated cases. This one's actually pretty straightforward. All right, let's move on to the next case. We'll go from sugar to lottery tickets. I have never bought a lottery ticket in my life, so I can't relate, but I hate gambling. I can't, it doesn't sit well with me. All right, who am I up to? Hey, Brian, go ahead. Can you give me a few of the facts in Champion versus Ames, also called the lottery case?
So Congress had prohibited the transportation of lottery tickets across the state lines.
And actually, these are from Paraguay, so actually it's even foreign commerce in a way. But go on.
I guess it was a Texas company that was sending the Paraguayan lottery tickets to California.
Yeah.
And they basically said that the railways are an instrument of commerce, and therefore they can regulate the transportation of the lottery tickets when they're on the railways.
Okay, good. Thank you for that. Blake, can I ask you a question, please? Blake, what is the police power? I think I asked this question last week, but I'll ask it again.
Well, I know at the time it was exclusively reserved to the states.
Well, but tell me who has it. Tell me what it is. How about start there?
The power, I mean, I don't remember the judicial language, but I know it's the power to restrict or prohibit certain activities for the public welfare.
Yeah, what kind? Chelsea, do you remember what kind? What are the different heads of the police power? Do you remember?
I do not remember. It's not the different branches.
No.
Regulated.
Brenda, do you have it?
Morally, right? Like things that are like
Maybe. Well, the three biggies.
healthy for people.
William?
Health, safety, welfare, morals.
Probably morals. I'll get to morals in a minute. Yeah, for sure. The states have long been understood to have this what's called this police power, the power to regulate the health, safety, and welfare of the people. Maybe morals, but that's really, I think, an invention of the progressive era, right? It's really in the progressive era that not only can we regulate health and safety, we can regulate morality. For example, banning alcohol, right? Banning lottery tickets, banning debauchery, prostitution, right? Banning different kinds of sexual relations, right? Where does the state get the power to do any of this stuff? The police power. So again, here in this case, there's no question that if Texas or California wanted to ban lottery ticket sales, they could do that, right? That's the police power. And it's funny, sort of the way they see lottery tickets as like these immoral, these like this parasite that's going to seize people's money and take things away from people. But the question isn't whether a state can regulate lottery tickets. It's whether the federal government can regulate it. So, Zoe, you were in the bathroom before, I think, so may I come back to you? So what does the court hold here? Can Congress ban the transportation of lottery tickets across from Texas to California or wherever it is?
They said that, yes, they can, since lottery tickets are subject to traffic, that makes it more subject to commerce. And therefore, they can regulate the transportation of tickets.
Okay. Was there a dissent in this case?
There was, yes.
Okay, we'll get to the dissent in a minute. All right. So here we have a situation where the majority flips, right? Zoe, who wrote the majority opinion?
It was Justice Harlan.
Yeah, ain't that something, right? This will tell you have to learn dissents. Harlan was in dissent in E.C. Knight in 1895. And then 8 years later, he got the last laugh in Champion against Ames. I think 8 years. Man, what were you guys doing 8 years ago, right? Were you like in high school or something, right? Yeah, something like that. Yeah. So he was on the court for almost 30-something years. So 8 years, just like, oh, whatever. But it takes time to sort of develop. Oh, she's not here. Predictability, right? The law developed sort of unpredictable fashion. It took 8 years to perhaps reverse this. Now, the court doesn't overrule E.C. Knight, but it's sort of hard to reconcile. You can reconcile it. But what Harlan says here basically is that if the states have the power to ban the sale of lottery tickets, then certainly Congress has this power also. Michael, I think you're next. Does that argument click for you that the states have this power, then certainly Congress must have the power also?
At first glance, no.
Okay, tell me what you're thinking.
Because I know that states have powers that Congress does not have.
Correct. Right. So this isn't exactly a, how do I put this? Harlan is pushing the law in a direction here. He's not restating McCulloch. I think he's going beyond McCulloch a bit. But he says that if the states have this police power, then certainly Congress must have it. But the long understanding is that Congress has never had a police power. All right. Harlan also focused on what he calls the channels of commerce, right? That the Congress can make sure that there are not these obstructions as commerce goes from one state to another. That actually these lottery tickets are kind of like a pestilence, almost like they're infestation. Like, you know, imagine like there's a cockroach or something, right? That you're trying to stop these cockroaches from spreading from state to state. It sort of over the top language, but this was sort of the morality of the time. Jake, what about the 10th Amendment? Harlan mentions this. Does the 10th Amendment reserve any powers to the states? How does the 10th Amendment play here?
No, I have a sources of law section and what is about that?
Nick?
Our regulated commerce in the states is delegated to Congress.
Right. It's true the states have these reserved powers, but Congress has the power to regulate commerce among the several states. But to be clear, this is not, again, a commerce clause case. It's necessary and proper. How do you know this? Chanel, let me ask you a question. Are they merely regulating commerce here? Prohibiting. Does the power to regulate include the power to prohibit?
I think that is seen differently by some.
What clause gets you the power to prohibit? Is it the Commerce Clause? What's always my answer to every question I ask you? Yes, ma'am. The power to prohibit, not just regulate, the power to prohibit has to come from the Necessary and Proper Clause. This is actually an important case that says the power to regulate includes the power to prohibit. It's actually sort of a broadening of federal power. So again, you have the 10th Amendment that the states have the reserved powers. We still have the Necessary and Proper Clause and the Supremacy Clause, which means the states can override that. Okay? Then we get to what I call the limiting principle issue. All right, what is the limiting principle issue? Whenever the I was going to ask rhetorical. Yeah. You guys are so smart. I love it. Right? What's a limiting principle? A limiting principle to the court says, well, we're reaching this ruling and we're going to do X, Y, and Z, but we're not, don't worry, we're not going to do this other stuff, right? As broad as this opinion is, we're limiting it. You know, for example, in Gibbons, the Chief Justice said, well, you can regulate a boat going into a state, but you can't regulate entirely internal commerce, right? That's a limiting principle. So Harlan says that we have a limiting principle here. Okay? But what does he say here? He says, the present case does not require us to decide the full extent of Congress's power. In other words, we don't have to decide all the power. You have to decide this here. Maybe in some other cases there's abuse, but that's not here. And he says, we don't need to lay down a bright line rule. All we're deciding is this case. Laura, is that much of a limiting principle? No. Not much. Anyone disagree? Maybe they see more. Yeah? Yes, I mean, he's basically saying we're just doing this case. We're not saying what else is there, but there's not much of a firewall thing. You know, in another case, you can't do this. So I think what Harlan's sort of hoping on or banking on is that, all right, you guys, going back to Chelsea's point, predictability, we're not going to tell you where this is going. We're going to decide this case and just bring us more cases to decide it. But he's hoping that he's now the majority. Yes, Trent.
Does this not seem kind of counterintuitive, saying it's like, oh, this only applies to this case, but it's the Supreme Court, so it's going to establish.
Yeah, such a good question. The court does this all the time. You ever hear the expression, take a good for one ride? Right, what does that mean? Sometimes you buy a train, maybe you've never been on a train before, I don't know, it's Texas, right? But in theory, there are trains in other parts of the country, And you could buy a ticket that works any day of the week. You can just get on and off as you wish. Or you buy a ticket good for one ride. Think of a plane ticket, right? If you don't catch your plane, you're out of luck. The Supreme Court does this all the time. They will say, this decision is limited to these facts. They do this all. They just did this in the TikTok case a couple weeks ago. They said, the facts here are very unique. Or Bush v. Gore. The facts here are limited to this controversy, right? They do this all the time. Does it work? No way. Because when the Supreme Court says something, as you notice, it does set a precedent. And lower courts do rely upon it. And I can tell you, today, is E.C. Knight good law? The answer is no. It's been not expressly overruled, but it's been basically overruled. Is Hammer good law? No, it is not. Overruled by Darby. I'll say that one next week or next class. But is the lottery ticket case, Champion versus Ames, good law? Yes, sir. So even though Harlan's saying, we're just limiting this to these facts, it's still good law. And I'll tell you, it's cited all the time for the proposition that the power to regulate includes the power to prohibit. Right? It's not just regulating the terms in which you buy something, it's banning it altogether. So even though Harlan's like, we're just we're just doing this case here, that never works. And they know that too. But they got 5 votes. This is also a thing. To keep 5 votes, you also have to put something that's like, we're not going too far. We want predictable judgment, right? We're not. That's all we're doing. Just doing this one thing with these lottery tickets, these pestilence, right? But it's a very broad case. But good question. All right. Anything else in the majority in the lottery case? What am I up to? And I think you're next. Can you go to Justice again? And here, Justice Fuller, our friend with the mustache, right? He is now in dissent. So I think I have a graphic representing this, right? So again, in E.C. Knight, Fuller was in majority, Harlan in dissent, and then reverse. Oh, it's an effect. Ooh, flips, right? And Champion, Harlan, majority, and Fuller's in dissent. What's this Fuller? He seems kind of annoyed here, doesn't he?
Yeah.
He's like, where my bros at? What happened? Where are you guys? What are you doing here? I lost my majority. What does he say here?
He's essentially saying that because it's obvious that the act was put in place to, encroach on the police powers of the states, that they're out of line by not ruling to uphold state rights.
Correct. Yes, exactly. Thank you very much, ma'am. So Justice Fuller is like, he goes nuclear here, right? He goes scorched earth. He's saying, this decision will destroy, he uses very strong language, right? Will destroy any distinction between the state government and the federal government, right? This is encroaching. He says, if you take Harlan seriously, there are no limits. This sort of rhetoric you'll see over and over and over again. Think of Justice Chase's dissent in the legal tender case, Knox v. Lee. Very similar language, right? And just compare these two, right? From Hepburn, here, go back to our PDF of the chart, right? From Hepburn versus Griswold to Knox v. Lee was a year. Chase was the majority here, dissent over here, right? And he's like, if you do this, you destroy the limitation. Now we go to E.C. Knight and Champion. Fuller's the majority here, dissent here. And he says the same thing. You are destroying the limits. It's the same rhetorical move. One side has philosophy of preserving the power of the states. The other side says we have a broad federal government. It's the same debate, whether it's about paper money or lottery tickets. It's the same thing that you see over and over again. These sort of tropes repeat. Okay? Questions? Oh, yes, go ahead, Chelsea. Go.
This one, I think I wrote in my notes, Congress has no power to regulate morality. That's the dissent.
That's what the dissent says. You're right. Yes, you are.
And then just thinking about morality in days like today.
Whatever could you be saying, my friend? What do you?
Okay, so just abortion is a thing.
Yeah, it's a thing. Yeah.
But is that not? I mean, this is my opinion, but is that not morality and not for in this theme or this thought process? Is that not should be state regulated versus?
Well, under the current law, abortion is now a state issue. Okay. There are federal abortion issues and federal properties, but the better issue is actually, this is mentioned in other cases, prostitution, right? Why is the federal government banning prostitution? You ever heard of the Mann Act? right? Transporting people across state lines for immoral purposes, right? You can't do that. The Caminiti was a human trafficking act. So in other words, there are lots of.
Because I'm just saying, like, that's morality. That's not in the Constitution. It's just, I don't know. Or it might be in the Constitution. I don't know.
Yeah.
I'm just curious because is that what that looks like today?
You will see, my friend, if you just sort of jump ahead, right? If we just jump ahead, there are a lot of cases that come after what we've read so far. And under the current law, the federal government can regulate just about anything, whether morality or otherwise. There are not many limits upon it. Sorry, not a very satisfying answer, I'm sure. You want predictability, take another class.
I just say that's what he said. I was just
Not in this class, unfortunately. All right. We go? Shake it off? Shake it off. Okay. What else? All right. We're good. We're good. We're good. All right. Let's move on. All right. So I think we got EC Knight down. We got Champion versus Ames down. Look at a Hammer. Hammer. Who am I up to? You. Damon, I think you're next. Damon, you want to please give me the facts in Hammer?
So, up in case of North Carolina,
Yeah.
they have history of child labor laws is federal regulation.
Okay.
Music bills are child labor acts.
So just take a step back. Could the states ban child labor?
So it's yes, they have
Okay, good. And I don't think there's much disagreement on this point. The states want to regulate child labor, they can. But who regulated child labor in this case, Damon?
in this case, they're at issue with the federal.
Correct. And so what was the actual law at issue? What did the law do?
They put like minimum wage, I guess, or an age where you had to.
All right, but just to be clear, what actually was Congress regulating? Were they regulating the wages or were they regulating something else? How? How are they regulating who could work? Closer, Rick?
Like about like time and how much they could work per day and stuff like that, like based on their age.
Let me ask the question differently. I'm not getting it across. Could Congress just come out and say we want to impose a minimum wage for children? Could they just do that directly?
We have that now.
I know we have that now, but that's a different story. I'm asking the 1920s.
I'd say no.
Why not?
I'd say that the states just still have more power over.
No, not Paulina?
I think your first question was, what were they trying to regulate? They were trying to regulate whether the shipment.
Correct. Correct. Say it again, please. You're exactly right, Paulina.
Or whether Congress can prohibit the shipment of products manufactured.
Yes, ma'am. She's right. To be very clear here, the law here did not directly regulate the wages of minors. It said that you cannot ship across state lines goods that were manufactured with child labor. Everyone got that. It's a very important distinction. Today, you're right. We have minimum wage and everything, right? That's a different story. I'm asking the 1920s. So, Karen, what was the problem, according to the majority opinion, with this regime?
They were basically saying that there wasn't a connection between the rules of basically them trying to force commerce on state rules. Like the state has the authority to control the trade and manufacturing, and they can only talk about commerce, and they just don't like that there's child labor involved.
Karen, let me ask you a question. Was this a direct regulation of interstate commerce or indirect?
Indirect.
Yeah, why is it indirect?
Because what they're essentially targeting is that they're against child labor.
But what they, in other words, what's on the surface and what's like underneath? Let's ask like that.
So on the surface is to them, what they're saying is that they want to regulate how goods are being shipped and what can.
Let me ask a question. You're giving a good answer, but what's the actual act that's being regulated here? What is this law regulating or prohibiting, I guess?
Child labor?
No, it's not. What's actually, what, this is Paulina's question a minute ago. What are they actually regulating?
The shipment?
The shipment. So on the surface, they're regulating the shipment. What are they really trying to do here, Karen? They're trying to regulate labor conditions. Very good. Thank you all. Okay. So this is a case, again, where the majority basically says pretext. Right? Pretext. Again, what's a pretext? The reason you're giving us for this law is not the real reason. Right? In other words, is banning child labor a legitimate end? Maybe by the states, but it's not for the federal government. It's not a legitimate end. And you might say, oh, we're trying to eliminate sending these goods across state lines or maybe with child labor. That's not what you're really trying to do. It's not an act of deference. They're being skeptical of this. The court says this is really about regulating labor conditions and not interstate commerce. How do we know this? Right? So, Stephen, let me come to you. How do we know that this law is not actually about regulating the shipment of goods? How do we know that?
Well, it's about well, like basically what they're in their opinion it talks about the wait, repeat the question.
How do we know this law is not really about shipment? It's about labor conditions. How do we know this is a pretext? How does the court figure that out?
Well, they basically say that there's like the act is like it has like a twofold sense related to the Constitution, and it's like I mean it's kind of like a broad question.
I know, I'm asking it.
Well, basically it's just like reinforcing that like the state's police power is being like infringed on, I guess, by like.
No. Sabina?
Oh, it's talking about the manufacturing rather than the commerce part of it.
That's part of it. Part of it, Sabina?
I was going to say that it's kind of similar to the Knight case I saw, like, because it is prohibiting the manufacture, it's interfering, and because it is under the umbrella of, like, the state. So it's.
Okay, so Stephen and Sabina said something correct. Congress can regulate the commerce, not the manufacturing, right? But this law, they say, is actually going after the manufacturer and not the commerce. In other words, the government's lying to us. But how do you know the government's lying? Taylor?
Because they said that the child labor is done before it actually crosses the state.
That's correct, right? But how do we know that this is not like the lottery case where they're just trying to stop the shipment of these things to the channels? Why is this not about that?
Because they say that the goods themselves are harmless.
Perfect. That's the answer. That's right. Say it again, please.
The goods themselves are harmless.
Are these
so
like
there must be something else.
are these bad lottery tickets like that will corrupt the morality of the people? The furniture's harmless. Is there any difference between sitting on a chair made by an adult and sitting on a chair made by a child? Maybe it's going to have a chair, but is there any actual difference?
No.
None. This is a signal that the government's not telling the full story. It is like my daughter who's 4. She always says, Daddy, why? If you ask the question why enough, why are you doing this and why are you doing this, eventually you get to the point where it's like, we don't want to tell you the full answer. If you have kids or younger siblings, you know this, right? They always get to the point, it's like, well, Daddy, you're not telling me something they know. So in other words, why is Congress doing this? They want to they want to clear the channels of child labor in the marketplace. Okay, and why do they want to do this? Because child labor is bad. But why do you want to stop the shipment of it? Well, the reason why is if you stop the shipment of it, then it's no longer profitable and you shut down the local industry. Oh, that's the reason. If you ban the shipment of this stuff, then companies won't want to make it because they need to make a profit. And you're basically backdoor, right? Through the back door, you can ban child labor. That's it's a pretext. This is where the means and the ends comes into play. You ask, what are you trying to do? We want to free the marketplace of these goods. And what's the means you're doing it? Right? You're banning the shipment of it. Is that really the reason why? Right? And I think if this isn't the case, you're actually allowed to ship it within 30 days after it's manufactured. So you can eventually ship it, just not right away. If this is such bad stuff, why couldn't you just stop it altogether? These are signals that the means, the ends don't quite line up. That maybe the government's not telling you the full story. And when you apply the sort of skepticism to the law, it doesn't pass muster. Oscar.
Can you say another way of like knowing the pretext?
I'm sorry, it's all what?
Like they're just trying to push morality. Like, would you say it's because like just like the oil case where it's like, well, why didn't you just tax the oil directly? Why don't they tax the good thing about the kids directly instead?
Yes. It's basically saying the means that you chose are not really related to the ends. If what you want to do is raise revenue for this type of oil, then why don't you just tax this kind of oil? Right? If what you want to do is actually ban child labor, why don't you actually ban child labor? Oh, I know the reason, because you can't. Because that goes beyond what was upheld in EC Knight. Because you can ban commerce, not the manufacturer. So again, Congress is trying to be a little bit cheeky here, right? They're trying to be cute. It's like, okay, we can't regulate local labor conditions, so let's make it unprofitable for these companies to make child labor through the back door. But then again, deference. What does Justice Harlan say? It's not for us to decide if this is legitimate. We should defer to Congress. Right? Now, let's do the dissent in, I'll get to the dissent in a minute. Actually, let me do the majority a little bit more. Right? So the majority basically says they don't say the word pretext, this is a pretext. If the reason given is not the real reason, and this ruling would basically obliterate the distinction between the federal government and the state government. Right? The states have the authority over labor conditions. And he says, this will destroy our system of government. I mean, you want to talk about some rhetoric. They're really hyped up here. Right? This will destroy our system of government. All right, any questions in the majority? All right, let's go to the dissent by Justice Holmes. And Justice Holmes is, I'm sure you've read his opinions. Have you read any Holmes decisions of the classes? He was just, I think he's overrated, in the same boat as Marshall, but he was a remarkable human being. He fought in the Civil War. He was shot like twice and survived. Just sort of, stunning. He lived a very full life on the court. And his sort of judicial philosophy was one of deference to the government. He once said, if my fellow citizens want to go to hell, I'll help them get there. I'll come to that one back later this semester. It's a case called Buck v. Bell. He believes it too. He believes if my people want to do something really bad, I will help them get there. So he's not going to be in the business of second guessing the government. If the government wants to impose this condition on labor, child labor, that will be for them to accomplish. Right? In his view, this case is just like Champion against Ames. You have the channels of commerce, and Congress can clear those channels of harmful goods, whether those goods are lottery tickets or child labor furniture. But again, this case was, again, 5-4. So you see these 5-4 cases ping-ponging back and forth over the course of 2 decades. All right. So where are we now? EC Knight, no longer good law. Never actually overruled. I've looked into this. No case ever actually said, we are overruling EC Knight, just kind of just passed away. Hammer was expressly overruled by a case called Darby. We'll say that one, I think, next class or next week. I can't remember. Champion remains good law to this day about the power to prohibit goods and the power to regulate morality through the federal power. So Hammer is still good law. Champion is still good law, I'm sorry. Okay, questions on these 3 cases? All right. Oh, yes, go, please.
So how do we know that Congress didn't just like, okay, we want to, encroach on state rights, but we want to put like an altruistic spin on it that we're not really.
Oh, they do this all the time.
Like, that's what it kind of like.
So there's another case that I don't assign. called the child labor tax case. It's called Bailey v. Drexel Furniture. It's not in the book, but I can talk about it for a minute. So after Hammer, Congress said, aha, I have an idea. Let's use a taxing power. And let's impose a tax on all furniture made by children. And what did the Supreme Court say? You're not going to fool us. You're doing the same thing. You're not really interested in raising revenue. You want to ban child labor. So first, Congress tried to ban it through the Commerce and Necessary and Proper Clause. Congress said no. Then they tried to ban it through the taxing power. Congress said no. It was actually interest of having an amendment to the Constitution to ban child labor, which never got past the goal line. But then eventually got to Darby, and the court just reversed course and said, yes, you can ban child labor. So your point of altruism is exactly right. Congress saying, we want to ban child labor. Supreme Court, stop being so difficult. And so I said, no, we're not. That's, you're just doing the thing we said you can't do. Okay, cool. I'll take it. You actually think that's cool? Or my answer was cool?
No, your answer was cool.
All right, that's
what I was thinking. So.
Even better. Great minds think alike. Okay. What else on the on Hammer, the Dagenhart? By the way, who are the plaintiffs in this case? It's kind of a weird one. It was actually the father filed the suit on behalf of his minor sons because children were incompetent. I don't mean in the sense they're stupid, but children lack competency to bring a lawsuit. You know this, right? You can't go to court. So it was actually the father suing the right of his children to work. Just, maybe not what you might expect. All right. Anything else in those three cases? All right. Let us move on to. So we started our class talking about the federal period, the Marshall Court. We talked about the Tawney Court, the Chase Court, the Progressive Era. We're now getting towards the end of the Progressive Era with Schechter. And this is sort of the last hurrah, right? UVC Knight, Champion v. Ames said you can regulate morality, you can prohibit commerce. Hammer sort of held the line saying, no, we're not going any further. And then Schechter Poultry also sort of held the line. What we'll see in the next class, we do the New Deal, is it goes whoop, 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 all the way out, right? Wickard is very far. Still not quite as far as Nazi Lee, but in each case goes further and further out. Schechter is the last line. So what is the New Deal? I'm sure you've studied this. Scott, I hope you studied this in some history. But during the late 1920s, early 1930s, it was viewed as a Great Depression in America. And there are many competing causes of why it happened. I'm not concerned about it here. But there was a rising sense that the government needs to take a stronger hand in the economy to alleviate the conditions of the Depression. Whether those worked or not, it's a different story. Okay. In 1932, President Roosevelt wins the election by a fairly large majority. And during his first 100 days in office, he enacts a wide range of legislation, sweeping legislation, that tried to sort of reshape the country. And one of these laws was the NRA. No, not the National Rifle Association. It was the National Industrial Recovery Act, actually the NIRA, to be precise. What was the NRA? The NRA established these codes of conduct that would govern different industries. And these codes of conduct were not written by Congress. Rather, they were written by what effectively were boards of people from labor and from industry who said, here's how we're going to do it. And you always had these, it's called the Blue Eagle. You had the Blue Eagle poster on your window to show that you were down with the NRA. So just take a step back. Before we get into specifics, who makes laws? I know it sounds like a dumb question. Who's next? Dylan, who makes laws? It sounds like a dumb question. It's not.
Legislature?
Yeah, the legislature. Did the legislature in this case establish how many hours that butchers could work and what kind of chickens you had to take? Yeah. So how does that work there, Dylan? Dylan, how can the executive branch make? Did we learn the first week in classes? The legislative branch, the executive branch. How can it be that you have the executive branch basically making laws? How can this work?
And it's not supposed to work, right? So
can Congress delegate its power to make laws to the executive branch? Joseph, what do you think?
not according to this.
Why not?
The power they were granted was to legislate, and if they delegate that to the president, as they did here, he pretty much has the discretion to do whatever he wants.
Well, is it unlimited discretion? There's certain guidance. Didn't the statute say that the president can approve codes of fair competition? Is that an instruction? President, you can approve codes of fair competition. Go ahead. Isn't that enough? Isn't that enough of a principle for them to follow? Yeah.
I mean, it's very broad, but
Yeah. Trent, what do you think?
well, I was going to think, I mean, you have like things like executive orders.
What's an executive order?
It's an order passed by the president, which essentially is used to like kind of make laws in a way, but really helps them like the idea behind it is that it helps you like execute. It's like basically kind of like a necessary and proper version of the president's power, where they can like make laws and regulations that help to like execute like the legislative intent, but also like the president's power.
Oh, you're no. Yeah. She emailed me before. Yeah. Oh, I called you right. Yeah, yeah. And let me ask you a question. If I tell you, yeah, and you, Evelyn, and Sabina, you're now aboard. Congratulations. And why don't you make a code of fair competition for students, right? You can say what are the fair rules. Have I given you a lot of guidance of what you should do? I told you, isn't it obvious what fair means? Isn't it obvious what competition means?
It just sounds broad. I don't know.
Yeah, it sounds broad. So how would a board know what's fair? Think back to what reasonableness, I suppose, is. This is brand new stuff, never happened before. There was the NRA is brand new. No here. Look at precedent. Yeah, there's no precedent here. Oh, their gut, the feels, the vibes, right? All right. So let me just tell you there's a concept in law, and it's somewhat controversial, but I'll just leave it there, which is called the non-delegation doctrine. The non-delegation doctrine. DELEGATION, the non-delegation doctrine. What does the non-delegation doctrine say? The non-delegation doctrine says that Congress, the legislative branch, cannot delegate its legislative power to the executive. Again, the non-delegation doctrine says that Congress, the legislative branch, cannot delegate its legislative power to the executive branch. This principle was understood to be pretty accepted, but now some people say it doesn't exist. I don't know. I just pretend it exists for this class at least. What the court has said over time is that this power of the legislation must be exercised by Congress. Schechter Poultry was a very significant case for a lot of reasons. So it's definitely a commerce necessary and proper clause case without question. But it's also a non-delegation case. And what the court says here unanimously is that simply telling an agency to pass codes of fair competition is not enough, right? Congress has not given enough guidance for what works. I shall tell you that this part of the case is no longer good law, right? The current standard today on the non-delegation doctrine is very broad. You mentioned executive orders, right? Bureaucracies, right? DOJ, right? Whatever it is, right? The U.S. Digital Service, right? DOJ. The rule today is that so long as Congress gives what they call an intelligible principle to the executive, that's enough. So, for example, if Congress says, President, executive branch, regulate the airwaves in the interest of fairness, that's enough. So long as Congress gives some principle to the executive branch, they can pass what effectively are laws. So the non-delegation doctrine is basically dead, mostly dead for what the Princess Bride, right? It's mostly dead. It has a little bit of juice. But Schechter Poultry is kind of like the peak, right? Where the court was saying, we are not going to enforce, or we're not going to allow these broad delegations of power. After this is downhill. After this, like, yeah, whatever you want. Executive branch, if you want to pass laws all the time, that's fine. Call them regulations, call them whatever you want. So the first part of this case is about the non-delegation doctrine. I probably won't come back to it, but you should know this. It's mentioned a lot in common discourse about the court. What I do care about, though, is chickens. By the way, I love this video. This is one of my favorite. Where is it? Yeah. I had so much fun making these. You have no idea. All right. So chickens. This is what they should look like, by the way, before COVID ruined me. These have short hair. Sabina, you next? Good. I like that attitude. What are the facts here in Schechter Poultry, please?
So basically, the company was at issue with labor violation.
What were the regulations that were imposed? Let's start there, please. What were the actual regulations at issue here?
Oh, that they were violating the live poultry code.
Okay, tell me what the code say.
That about how the poultry was reached in the markets, how they were butchered and reached.
What was the specific rule that was being violated?
The quality of the products that were being sold.
Kind of, Laura?
The straight killing.
Yeah, what's the straight killing rule?
I think it said that like you had to accept the chicken.
Good. Yeah. So here's how it works. Sorry, I'm a little hungry. I got Big Dad this thing afterwards. I have not to eat. Anyone here Jewish? Kosher food? Anyone what it is? Okay. So who are the Schechter brothers? They were kosher butchers in Brooklyn. And I think my great-grandfather didn't work for that butcher shop, but worked as a butcher at the same time. So I'm sure he knew them, but one can't be certain. Where I have a picture of them somewhere. It's in the textbook somewhere. Anyway, under the rules of kosher, the rules of kashrut, you can't have a sick chicken. What does that mean? If a chicken has any sort of blemishes or marks, you can't eat it. So as a result, if you go to a kosher butcher shop and you see a sick chicken, you can't take it. You can't eat that one. But the rules adopted by this board, by this Fair Labor Code, said that you have to basically take whatever chicken they give you. You can't pick and choose. And the idea was we want to reduce waste. We don't want to have all these chickens that are going to be wasted. As a result, a kosher butcher shop was not able to comply with this law. They also imposed a 40-hour work week and a minimum wage law. But the real big thing here was the fact there was a kosher butcher that was opposing it. Now, in today's world, this would be a religious liberty challenge under the Free Exercise Clause, that you're having a law that burdens their religious exercise. But it wasn't litigated as a religion case. It was litigated as a commerce case. Oh, yeah. No, Brett, back to you. So, Brett, let me ask you a question, please. Twice in one day. I'm sorry, it's back row. Crazy, I know, right? So, Brett, let me ask you a question, please. Where did these chickens come from? Were they raised in Brooklyn? So the chickens are being traveled from out of state, right? Did this law regulate the transportation of the chickens?
It was just the interstate, the sale, or the chickens coming in.
Just I want to be very clear. What was the actual activity that was being regulated here?
The killing.
Right. And that happens where?
In New York.
In Brooklyn.
Right.
So was this regulating the commerce or the sort of manufacture/slaughter?
Manufacturers.
So what does the court say here?
That neither the slaughtering nor the sales, rather than the transactions of interstate commerce with local.
Very good. Very good. So this case basically goes back to E.C. Knight, right? That before you have commerce, you have manufacture. In this case, it's actually the opposite. First, the chickens were shipped in interstate commerce, and then they're slaughtered. They're not regulating the shipment of the chickens. They're regulating how the chickens are slaughtered within Brooklyn, which is within one state. So this is not actually a regulation of interstate commerce. Okay. Moreover, this doesn't even regulate just the shipment of the chickens. It regulates how much you're paying your workers, how many hours they're allowed to work, and what kind of chickens can be taken from the coop, right? I think there's a coop. So this is, again, a necessary and proper clause case. It goes beyond Congress's implied powers. The court says the flow of interstate commerce had ceased. The poultry came to a rest within Brooklyn. And I think almost every chicken was sold in Brooklyn. It wasn't shipped back over state. If it was, that'd be surprising. Okay. Everyone with me so far? Then the court turns to the necessary and proper clause, right? They discuss whether these transactions affect interstate commerce. And here they say they haven't actually been convicted about affecting interstate commerce. They were only affected for what? The sale of a chicken in Brooklyn. You know, maybe you could show that because they were doing this, the kosher slaughtering in Brooklyn, this really affected the sale of chickens in New Jersey. Possibly, but that wasn't what they were charged with. That wasn't the case here. This was a fairly small butcher shop, and there was no basically effect in other states. Okay. They used the direct, indirect line from EC Knight. They still say this is not a very precise line, but the regulation of the sale of chickens remains within the domain of state power. And the majority says, if Congress regulate local chickens, that would destroy the states, because the states would be subject to federal control in federal courts. This is sort of this hyperbole we see over and over again. Okay. Questions? Oh, yes, Angelica, and then Sabina. Who's they? It wasn't Congress. It was the board. Why do you think he approved it? Can I give you an answer? You're not going to like it. So, sorry, this is my law and economics hat. I'm sorry. So on one level, this was designed to help people, right? On another level, it's designed to help workers. How do I put this gently? Helping consumers is not the same as helping workers. They're often actually at odds. What do consumers want? Goods at lower prices. What do workers want? Higher wages, better working conditions. Those are not the same thing. You can help one and not the other, right? By imposing minimum wages and maximum work hour weeks, you are raising the wages, which increase costs, which will probably make the chickens more expensive. And also these chickens are now picked up, not the one you want, but the sick chicken that you maybe don't want. So who is making these laws? Is mostly unions and the employers. These were designed to raise prices. We will study another case next week called Wickard v. Filburn that limited how much wheat a farmer could actually grow. Why would you limit how much a farmer could grow? Because, you know, with your curves, when you limit supply, the prices go up. So almost all of Roosevelt's policies resided in increasing costs. That was the express purpose. Does that actually get you of a depression? Someone else can argue about that, right? But these are measures designed to increase costs. Now, again, you're increasing wages, right? So there is some benefit there. But primarily the effect was there. Another element here that's not as well known, but perhaps is useful, is competition. If you have a small butcher shop, it's very hard to comply with these rules. Why? You might only have 1 or 2 people working around the clock, but have the limit to 40 hours a week. Bigger butcher shops that are established in industry can easily have this. Okay, you work this shift, you work this shift. So almost all the regulations from this era were designed to help entrench businesses, the bigger ones, and harm competition. So they were called fair competition codes. They usually have the exact opposite effect. They shut down smaller businesses and they raise costs. But that was sort of the MO of most of the Roosevelt proposals. They thought by raising costs, you keep the economy alive and so on. But these laws didn't actually work. In fact, the NRA was viewed as such a disaster that a 9-0 decision, this was unanimous, Louis Brandeis, my goodness. You say Brandeis at all? Louis Brandeis, the progressive himself, the icon, said this was unconstitutional. This was such a disaster. It was like, we got to get rid of this thing. We got to stop it now. It didn't work at all. This was one of the Roosevelt's, landmark achievements, and it lost 9-0 at the Supreme Court. Sabina, patiently waiting.
Sorry. Going back to, Schechter and discussing whether, it's commerce or the manufacturer and if it's about the good, couldn't an argument be made that the quality of the poultry?
I was going to get that, yes. Right. So the government actually argued, here's the line of reasoning. I was going to get to the very next point, next bullet. So you are on point, my friend. They said, look, if people are working longer hours, right, maybe they get tired, maybe they get sloppy, and maybe they don't do a good job slaughtering the chickens, and maybe the chickens get, sick, and then people eat them and their health suffers, right? What does the court say to this argument, Sabina? They address it. They address this opinion. Anyone else? Oh, go ahead. Yes.
It's more indirect, I guess.
Yes, ma'am. Exactly. It's too, I use the word attenuated. You know what that means? The fit between one side and the other is far too gap. In other words, if A to B, then B to C, then C to D, and so on, once you start piling one inference upon another, the government has unlimited power. So I'll just give you an example of study in a week or two. Gun-Free School Zone Act. Congress tried to ban possession of guns in school zones. They said, well, if there are guns in school zones, then children might be afraid of the guns. And if they're afraid of the guns, they may not learn as well. And if they don't learn as well, they may not get good grades. If they don't get good grades, they won't get good jobs. And if they don't get good jobs, they won't make a lot of money. And that affects interstate commerce. Don't laugh. This was an argument raised by the government. I'm exaggerating a little bit, but not by much. And what the court said is, no, you can't do that. You're putting one inference upon another upon another. You can't make a chain, like a chain of inferences. You can't chain it, right? You can't go A to B, B to C, C to D, E to F, right? It has to be closer, direct, the way it used to be in the years, right? It has to be a direct relationship. And the relationship between interstate commerce and a chicken being slaughtered in Brooklyn is far too weak. There's not a close enough fit. There's an indirect regulation of commerce under D.C. Knight, and therefore it's unconstitutional. Okie doke. Questions on Schechter? Got Schechter? Understand it? Good. It's not good law anymore, right? Our next class. Let me just pull up the syllabus just to show you where we're heading. Next class for the 5th. Make sure I'm just reading this right. I'm sorry. Right. So in class, no, don't pack up yet. We're not done yet. You guys are just 2 places away. I got time left. I'm not done. I'm telling you what's going on. So where have we been so far? Where are we headed? Right. We've made our way through the progressive era, and starting next class, we're going to do what comes after 1936 and 1937. These are sort of the pivotal points in the turn of American history. Right after the 1936 election, Roosevelt wins a second term. And starting in 1937, the court sort of changes trajectory. Why they changed course, we'll talk about next week. But they start, as the chart will indicate, going further and further and further, broader sense of federal power. The direct versus indirect line, that's gone. Adios. The idea that you have to carefully scrutinize the means and the ends, that's also gone. What the court basically says is, if Congress does it, that's legitimate. That's an easy one, right? Ask how many of you guys what legitimate means. I'll give you an easy rule. If Congress does it, that's good enough for me. If it gets the House and the Senate, the president's signature, that's legitimate. They might be laughing, but predictable, right? That's a predictable rule. But it also means a majority of Congress do whatever the heck they want, right? So balance that out. Jones and Laughlin Steel says that you can now regulate local manufacture, which kills off EC Night. Darby says you can regulate local labor and wage conditions. That basically overrules Hammer and to some extent Schechter Poultry. And then Wickard is the broadest of them all. That says Congress can regulate wheat grown on a farm that will never leave the state. And that is the sort of the high point of the court's necessary and proper clause cases. We will also study next week the Warren Court with 2 cases decided during the Civil Rights era. And these cases concern discrimination in discrimination in hotels and restaurants, and whether Congress can prohibit racial discrimination in these so-called public accommodations or common carriers, if you will. Okay, questions? Yes, Trent, and then Sabina.
The weed case is that kind of an outlier though, because it was creating a lot of like response to like industrial like the practices of farming that like destroyed like the supply of like weed stuff, right?
What do you mean outlier? It's still good law.
I guess not outlier, just like it seems like it's kind of more niche than like.
It's a precedent of great import. It's not an outlier. It's law. Sabina, go ahead, please.
So would you say that the problem with Schechter is that it was just trying to do too much with the regulations were trying to
Do you mean the NRA or Schechter?
Well, in general, I mean, I think we're talking about like the standard increases.
Right.
There's just so much happening. You know, there's labor, there's this, there's that. You say that that's when it kind of.
Okay, so your question, yeah, the NRA, I think without question, it tries to do too much, right? It tries to create these boards where they're negotiating these codes, delegating power from the legislature to the Congress, and then imposing these as criminal enforcement. They're going to jail, right? They're going to jail for picking out the chickens, right? This is a big deal. That's why they lost 9-0. I think Roosevelt came in perhaps too hot, as we might say today, and maybe tried to do too much too fast. But he regrouped. And by 36 in his second term, he basically got just about everything he wanted. That's funny.
No, I'm just saying it's interesting.
History is fascinating, right? I mean, as we learned, sometimes first term, you have the second term. All right. In 20 minutes in Garrett Towns, please come. I want to see you and come to the judges event. I will go down there soon, but thank you all so much. I'll see you all in 20 minutes, I hope. If not, I'll see you on Wednesday.